Hello and welcome to Point One. 6 minutes of ethics a day could keep the legal malpractice claims away. No guarantees, of course. Today I wanted to talk about the third element in a legal malpractice claim and how ethics interacts with the third element, proximate cause. Again, a reminder, the four elements of a legal malpractice claim are privity, the attorney-client relationship. The negligence element, number 2, is a breach of the standard of care. And then here, number 3, proximate causation, which I'm sure everyone's familiar with. And then 4, actual and ascertainable damages. As I've said, negligence is not enough. You have to have proximately caused the damage to your client. So all 4 elements are required. And, typically people say that would be malpractice, referring only to the second element, not really thinking about the proximate cause issue. In the criminal context, and I think this really illustrates the proximate cause element, and in the criminal context in New York and many jurisdictions, there's an innocence requirement. So if the criminal defendant took a plea deal and allocuted and admitted to the crime, they are barred from a subsequent legal malpractice claim unless they're able somehow to vacate that admission. And that the criminal innocence requirement can and is used in the civil context in instances where admissions by parties can be used to bar a legal malpractice claim. So again, the proximate cause can be severed by admissions from the client party. And as we talked about before, the at-issue doctrine allows attorneys to use their client's privileged information in defense of a legal malpractice claim if the client affirmatively put that privileged communication at issue. So the proximate cause standard, it's but for causation, and always something to think about is prior, subsequent, co-counsel, who was involved and when. The sophisticated client doctrine is available in New York as a defense, and essentially, recognizes that certain clients are more sophisticated than others, and so the proximate cause, as it relates to, an unsophisticated pro bono client, would be a different test than proximate causation as it relates to a real estate developer who is suing their real estate attorney for some issue in a real estate transaction that they should have been familiar with. So clients will be held to a slightly higher standard in certain situations. Client satisfaction and speculation really come into play here in the proximate cause element. And, client dissatisfaction is really the main source of legal malpractice claims. Luckily for lawyers, it's not enough. It has, the breach has to approximately cause the damage, but that really is something to always keep in mind. The client satisfaction. Once you start to notice dissatisfaction coming from the client, or if the client has unrealistic expectations, those are good warning signs that maybe you need to find a way out of the case as possible. Ethical considerations and the proximate cause element of legal malpractice claims. The biggest one is that as attorneys, we are agents of our client. We can bind our client. We have actual and apparent authority. And, it's a heavy duty, and it's one that we deal with every day, but need to remain cognizant about, and this especially comes into play in settlement considerations. Of course, everyone knows, the duty to communicate settlement offers, demands immediately, but the settlement question is a serious one. I had a case where there was a mediation. The attorney, my client attorney, and his client went to the mediation. There was a business dispute between two partners. They were both stealing from each other, and eventually they got tired of stealing from each other and separated, and it resulted in a lawsuit. At the mediation, this was back before COVID, so everybody was in a room. They went to breakout rooms. The case settled. The mediator, highly respected mediator, was shuttling back and forth, getting everybody on board. They reached a settlement, and the client plaintiff did not sign the settlement understanding. The attorneys signed them. A few days later, the client who agreed, and I spoke with the mediator who told me the client agreed to the settlement, changed his mind and decided he hadn't agreed to the settlement. He had some handwritten note that he provided that he claimed directed his attorney not to settle the case at the mediation. It was all bogus. But of course, the mediator wasn't going to testify and had made clear that his organization would resist any subpoena. And so, we were stuck with a case where because of the agency relationship, the attorney-client relationship, the proximate cause element was really a hurdle for us in defense, because we had this sort of he said, she said at that there was settlement at the mediation. We ultimately settled the case at a mediation, and all the clients signed, not the attorneys, and everything worked out. But it's something to definitely keep in mind there. Communicate all settlement demands, offers, anything of substance in the case in writing as soon as possible, even if it's just a short email saying this development happened or this offer came in, evaluation to follow. And then you have a phone call and you discuss whether the offer is acceptable or not, or if this development changed your strategy or anything like that. But just a quick email to memorialize that it was communicated is really key to risk reduction. Mistakes happen all the time. The rules, the law acknowledges this, that not every mistake amounts to a violation of the rules or to malpractice. Most mistakes do not cause recoverable damage or amount to an ethics violation. And that's good, but it's still a failure of our professional duties to our clients, and it's something, of course, you want to avoid and reduce as much as possible. That's been our point one for the day. Thank you for joining us.